Welcome to the SafeSimpleSound podcast, where our approach to financial planning creates both and solutions for the contradictions families face every day. We believe that true financial confidence doesn't come from chasing the hottest trends, but from building a foundation that is safe, simple, and sound. I'm speaking with you today, drawing from our team's chartered financial consultant background and our extensive S3 framework development. Today, we are continuing a critical conversation about the bedrock of your financial safety net, your contracts. This is part 2 of our deep dive into the legal architecture of insurance. In our last discussion, we asked, is your financial safety net actually tied? Today, we are exploring a concept we recently wrote about on the SafeSimpleSound blog under the title, The Rules of the Game Are Different. We're discussing this because we've observed a very specific, common frustration in our practice. Most of us treat insurance contracts like any other purchase. When you buy a car or a house or even a gallon of milk, you understand the rules. You pay a price, you get a good. If you don't like the terms, maybe you negotiate. If you don't like the price, you haggle. But then you sit down with an insurance policy, whether it's life, disability, or long-term care, and the rules feel completely alien. It feels rigid. It feels like a take-it-or-leave-it ultimatum. This creates a contradiction that makes many families feel unsafe. The standard rules of commerce imply fairness through negotiation, but insurance feels like a one-sided game where the house holds all the cards. Here's the S3 perspective. That feeling of rigidity isn't a trap. It is actually a protective mechanism. In today's episode, we are going to translate the legalese that governs these contracts. We are going to look at two specific concepts, contracts of adhesion and aleatory contracts. Now, those sound like complex law school terms, and in a way they are. But our goal today, aligned with our simple mandate, is to translate them into plain English. Because once you understand these rules, you realize they aren't rigged against you. In fact, based on our analysis of financial instruments, we find that these rules are often designed specifically to protect you, the policyholder. Whether you are currently reviewing a policy or you've had one in a drawer for 20 years, this episode will give you the ability to read that document, not with anxiety, but with authority. Let's establish our foundation for today. To do that, we need to address the safe component of our framework. Safety comes from clarity. Fear usually comes from the unknown. When we look at insurance contracts through the S3 lens, we want to remove the fear by removing the unknown. Let's tackle the first big concept, adhesion. In our practice at SafeSimpleSound, we often hear clients express frustration that they can't change the fine print. You can negotiate the price of a used car. You can negotiate the closing date on a house. But try telling an insurance carrier you'd like to rewrite paragraph 4 on page 12 of your policy. It won't happen. This is because insurance policies are legally defined as contracts of adhesion. This means the insurer writes the contract, every single word of it, and you must adhere to it. It is a non-negotiable instrument. On the surface, that sounds incredibly unfair. It sounds like the big corporation is bullying the individual. However, drawing from our understanding of contract law within the financial planning space, we want to flip this perspective. There is a massive hidden benefit here that is central to your financial safety. Because the insurer wrote every single word, the courts hold them responsible for every single ambiguity. There is a legal doctrine called contra proferentem. In simple terms, it means interpretation goes against the drafter. Think of it like a tie game in baseball. In baseball, the tie goes to the runner. In insurance law, the tie goes to you. If there is a sentence in your policy that could be interpreted in two ways, one way that helps the insurance company and one way that helps you, the court is legally bound to choose the interpretation that helps you. Why? Because you didn't have the power to negotiate. Because it was a contract of adhesion, the burden of clarity is 100% on the insurance company. From a safe, simple sound perspective, this provides the stability we look for. While it feels annoying that you can't change the terms, that rigidity is the very thing that arms you with powerful consumer protection. If a term is vague, you win. This is a sound principle. The system balances power. The company gets to write the words, but they are punished if they write them poorly. Now let's move to the second concept, aleatory contracts. This explains why the math of insurance feels so different from the rest of your financial life. When you go to the grocery store and buy a gallon of milk for $5, you are engaging in a commutative contract. You give $5 of value, you receive $5 of product. It is an equal exchange. We are comfortable with this. It feels fair. Insurance is different. It is aleatory. This means the exchange is unequal and dependent on a chance event. Consider two scenarios we see in our practice planning models. Scenario A. You pay premiums on a term life insurance policy for 30 years. You live a long, happy life. The policy expires. You paid thousands of dollars, and the insurance company paid you zero. Scenario B. You pay your first premium of $100. Sadly, a tragic accident occurs the next day. The insurance company pays your family $1,000. In both cases, the exchange was unequal. In the first, you paid more than you got back in cash. In the second, the company paid vastly more than they collected. Many people view scenario A as losing money. They say, I paid all those premiums and got nothing. But through our SafeSimpleSound methodology, we encourage you to reframe this. This isn't a bug in the system. It is the essential feature. You are not buying a product. You are buying the transfer of risk. If insurance were commutative, dollar for dollar, it wouldn't work. You would have to save $1,000 to have $1,000 of protection. That isn't efficient for a young family. An aleatory contract allows you to leverage a small amount of money, the premium, to secure a massive amount of protection, the death benefit, precisely because the exchange is based on uncertainty. This aligns with the principle of sound structure. We accept the unequal math because it provides the safe outcome of protection against catastrophic loss. We are trading certain pennies for uncertain dollars. So when we integrate these two concepts, adhesion and aleatory, we see a shift. We move from feeling like victims of a rigged game to understanding that the rules are different because the function is different. We aren't buying milk. We are securing a promise. Now that we've established the legal groundwork, let's look at how this plays out in real life. Specifically, let's talk about your role in this relationship. Because the contract is aleatory, because the company is taking a huge financial risk on you for a small premium, the law asks something specific of you. It asks for utmost good faith. In a used car deal, the legal standard is often caveat emptor, buyer beware. The seller doesn't have to tell you everything unless you ask. But in insurance, the standard is total honesty. To illustrate this principle and the risks associated with it, let me share a hypothetical scenario. Please note, the following story is a fictional example created for educational purposes to illustrate the concepts of warranty versus representation within the SafeSimpleSound framework. While this story illustrates patterns we observe in the financial planning landscape, it does not depict any specific real-world client. Imagine a fictional client named Robert. Robert is a diligent 45-year-old architect. He likes order. He likes things to be sound and structured, very much in line with our S3 philosophy. Robert decides it's time to secure life insurance to protect his wife and 2 children. He sits down to fill out the application. It's long. It asks a lot of medical questions. Robert is generally healthy, but he's in a hurry. There is a question that asks, have you ever been treated for cardiovascular disease? Robert thinks back. He has high blood pressure, but he takes medication for it, and his doctor says he's fine. He doesn't think of high blood pressure as disease in the same way he thinks of a heart attack, so he checks no. There is another section, a statement of facts, where he affirms, I guarantee that I have never used tobacco products in any form. Robert is a non-smoker, but 5 years ago at a bachelor party, he smoked 1 cigar. He honestly forgot about it. He signs the document. 3 years later, in our hypothetical scenario, Robert tragically passes away from a stroke. His family files a claim. The insurance company investigates. Here is where the concepts of warranty and representation come into play. And this is the critical distinction we want our listeners to understand. A representation is a statement you believe to be true to the best of your knowledge. A warranty is a statement you guarantee is literally factually true, regardless of your intent. In Robert's case, his answer about the heart disease might be considered a representation. If he honestly didn't understand that hypertension was classified as cardiovascular disease in that context, and he was acting in good faith, the law often protects him, provided the adhesion contract wasn't clear enough. However, the tobacco statement, if the policy language framed that specific declaration as a warranty, a guarantee of literal fact, the forgotten cigar could be a problem. In strict legal terms, a breach of warranty can sometimes void a policy instantly, even if the mistake was innocent, and even if the death had nothing to do with the breach. Now, most modern policies lean toward representations rather than strict warranties because of consumer protection laws, but the principle remains. The burden is on Robert. While this story about Robert is fictional, it demonstrates how our framework views the concept of utmost good faith. From an S3 perspective, Robert failed the simple test. He assumed he knew what the terms meant rather than disclosing the nuance. This example shows patterns we observe when families rush through the application process. They view the application as a formality, like a terms and conditions checkbox on a website. But remember, this is an aleatory contract. The company is putting up hundreds of thousands of dollars based entirely on the information you provide. If that information is flawed, the foundation of the contract cracks. This aligns with the principle of integrity. The sound approach isn't just about the company paying the claim, it's about the applicant building a claim-proof application. If Robert had applied S3 thinking, he would have operated under the principle of over-disclosure. Instead of checking no on the heart question, he would have written, I have high blood pressure controlled by medication. Instead of ignoring the cigar, he might have asked his agent, does a single cigar 5 years ago count? By doing so, he shifts the burden back to the insurance company. Once he discloses the fact, the company decides to accept the risk or not. If they accept it, they can rarely use that fact against his family later. He has successfully adhered to the contract in good faith. Whether you're facing this exact situation or simply reviewing your annual benefits enrollment at work, the lesson is the same. In an aleatory contract, your honesty is the currency that buys the coverage. Simple disclosure is your best defense. When in doubt, tell the truth. Tell more of the truth than you think is necessary. As we wrap up this deep dive into the rules of the insurance game, let's summarize the key insights we've uncovered today. We started with a contradiction. Insurance feels unfair and rigid. We resolved this by looking at the SafeSimpleSound reality. 1, it is a contract of adhesion. You can't change the rules, but because of that, any confusion in the rules is interpreted in your favor. That is a safety feature. 2, it is an aleatory contract. The exchange is unequal. You pay a little, they promise a lot. This leverage is what makes insurance a sound financial tool. 3, it requires utmost good faith. Because the deal is so good for you, the leverage, the standard of honesty, is higher. Our goal at SafeSimpleSound is never to make you a lawyer. We don't want you to memorize Latin phrases like contra proferentem. We want you to feel the safe energy of knowing that these contracts, while complex, are navigable. So, what is the practical next step? How do you apply this to your financial life this week? Drawing from our practices methodology, we suggest a simple audit of your mindset. When you look at your policies, stop trying to negotiate the non-negotiable. Instead, focus on your duties. Are your representations accurate? Did you answer the questions with utmost good faith? To help you with this, we have translated these complex concepts into practical tools. This episode draws from our recent blog post, The Rules of the Game Are Different, which you can find at SafeSimpleSound.com. Through our S3 approach development, we've created 2 specific resources that accompany this topic. First is the Rules of the Game Policy Decoder. This is a simple translation guide to the complex terms in your policy jacket. It helps you spot where the adhesion language is actually helping you. Second is the Is It Tied Vulnerability Audit. This is a confidential assessment designed to help you see if hidden good faith errors, like our fictional friend Robert's, might be putting your coverage at risk. If today's S3 insights resonate with your family situation, we invite you to explore what financial planning could look like through our SafeSimpleSound practice. We help families navigate these contradictions every day, moving them from confusion to clarity. But even if you never choose to work with our team, we want you to walk away from this episode with value. You are now equipped with a capability, the ability to understand the why behind the what of your insurance contracts. You understand the rules of the game. And when you understand the rules, you can stop fearing the outcome and start trusting your foundation. Thank you for listening to the Safe Simple Sound podcast. Until next time, keep your planning safe, keep it simple, and keep it sound.